I'm Melissa Mancini with Canadian HR Reporter TV. I recently sat down with Rachel de Grâce from the Canadian Payroll Association to talk about the complexities involved when determining province of employment.
Just to put things into perspective, there are 191 pieces of legislation that payroll has to adhere to, and many of which actually come into play when talking about the employee's province of employment. Because we have certain rules for statutory deductions, such as CPP or EI or income tax, but then there are other considerations as well, such as employment standards, pension standards, workers' compensation, and all of the other employer taxes. A really common scenario is when an employee lives in one province, they go to another province to work in, they report to a supervisor or manager who is in yet another province, and they travel from time to time, even between all of the different provinces. So where an employee actually lives or resides is actually irrelevant when determining the province of employment for compensation, for statutory deductions, employment standards, and on all the other considerations. So both the CRA and the Quebec Taxation Act define the province of employment when it comes to statutory deductions as well as employer taxes as the province where, or the territory where, the employee physically reports to work at an establishment or a deemed establishment of the employers. So if you think about restaurants, as long as the employee is physically reporting to work at that restaurant, then whatever province or territory that restaurant is in, that will be considered their province of employment. The tricky part is this whole idea or concept of a deemed establishment. A lot of people work from home these days. And if you are not required to set foot in any establishment of your employers, then the province of employment would be the province where you are paid from. And that basically means the province where payroll is being generated from. If you're working from home in Alberta, but you're being paid through the headquarters, the payroll department is in Quebec, then yeah, unfortunately, the employer has no choice but to treat you as a Quebec employee. Now, when you file as an Alberta resident at the end of the year, you will get back all of those really high Quebec taxes. And, so that's the good news for the individual. But the employer still has to pay all of those Quebec employer taxes, and they will not be entitled to any type of refund. Well, the other big thing is this concept of deemed establishment. So when it's an employer's establishment, it means that there's a physical building, and that's very easy. A store, a storefront, a restaurant, an office building, a warehouse. But other times there can be a situation where both the CRA and Revenu Quebec will determine that there is still a deemed establishment. So there's two big examples or easy examples that come into mind. If an employee is working from their own home, but they have the authority to contract on behalf of the employer from their own home, and this is not dependent on any type of follow-ups from head office, there's no further sign-offs or anything like that, in that situation, this salesperson could actually be considered to be working in a deemed establishment of the employers. And in that case, their home residence, that province or territory, does become the province of employment. And the other scenario is if there's heavy equipment involved. So for example, if you think of a new condo going up, the contractor or the builder perhaps doesn't own the site, they're simply building on the site. But if they've got a crane that is sitting there, that's considered a substantial piece of machinery. Or perhaps there's a trailer where the supervisor might work from, then even though they're not paying rent on that piece of property, they don't own that piece of property, again, this could be considered a deemed establishment, and that would be the province of employment.